of senators yesterday has to be put in context. The overwhelming majority of senators on both sides, I thought, were asking appropriate questions and positive in their approach and respectful of the nominee before us. But for many of senators, yesterday was an opportunity to showcase talking points for the November election. For example, all Democrats are soft on crime, therefore this nominee must be soft on crime. Well, you've made a mess of their stereotype. The endorsement of the Fraternal Order of Police, the International Association of Chiefs of Police, just doesn't fit with their stereotype of a Harvard grad, black woman who is aspiring to the highest court in the land. But you earned it. Law enforcement is on your side because you've been on their side at critical moments. And your family has dedicated a big part of their lives to law enforcement, and you obviously believe it at your core. You said that over and over again. So the soft on crime charge, which leads all others, falls on its face. The second thing is that you are somehow out of the mainstream when it comes to child pornography cases. And of course, that gets down to the question of sentencing and your choices in sentencing. It is difficult, if not impossible, for each of us to put ourselves in your place when you are facing all the totality of facts concerning a certain defendant, then looking at your requirements under the law as enacted by Congress and trying to do the right thing to keep America safe, but to meet justice. You are in the same place as 80% of federal judges when it comes to sentencing on child pornography cases, 80%. And of course, Congress is not without fault. We have failed to pick up the responsibility that was assigned to us some 17 years ago when the Supreme Court decided that the basic guidelines would not be mandatory on judges. We should have stepped in at that point. But it's a tough, hard, controversial subject, and we've stayed away from it. And what has happened is the judges have tried to make do with a fractured situation where they have guidelines that are advisory, they have opinions coming to them about sentencing from the government, as well as from probation office and others. So I would say that the bottom line is this. You have done what 80% of the judges have done. You're in the mainstream of sentencing when it comes to child pornography cases. I also think it's ironic that the senator from Missouri who unleashed this discredited attack refuses to acknowledge that his own choice for federal judge in the Eastern District of Missouri has done exactly what you did. You also have been criticized as having been wrong to be a public defender or even to be in a law firm representing a Guantanamo detainee. It's interesting that Republican judges, very conservative ones, don't see this as a blemish on your character. They understand, as we do, that the Sixth Amendment creates a responsibility that people have a right to counsel. You have exercised that responsibility in your professional life. This, incidentally, yesterday, your nomination turned out to be a testing ground for conspiracy theories and culture war theories. The more bizarre the charges against you and your family, the more I understand the social media scoreboard lit up yesterday. I'm sorry that we have to go through this. These are not theories that are in the mainstream of America, but they have been presented here as such. Finally, you are a respected, successful woman of color. You've been approved 3 times by this committee for increasingly significant judicial assignments. Now the President of the United States has chosen you to serve on the highest court of the land. America is ready for this Supreme Court glass ceiling to finally shatter. And you, Judge Ketanji Brown Jackson, are the person to do it. Senator Grassley.
Mr. Chairman?
Yes.
Mr. Chairman, I think you've, in the main, provided both sides an opportunity to be heard and ask their questions. But unfortunately, I noticed that after every series of questioning on this side of the aisle, you choose to editorialize and contradict the points being made by this side of the aisle. I don't know whether we will have an equal opportunity to editorialize about the advocacy that you and your colleagues, the points that you're trying to make. I especially was concerned that after my questioning yesterday, I left the hearing room and you chose to come back after a break and raise with the judge a point that I had asked her about, and which I frankly think was misrepresenting my position and what the facts are with regard to whether the judge has accused President George W. Bush and Donald Rumsfeld of war crimes. My language was, I asked her whether she'd called them a war criminal, and she said under oath to you, no, I did not, although the record is plain as it can be that she accused them of war crimes. Now, I don't understand the difference between calling somebody a war criminal and accusing them of war crimes. Maybe in some other foreign language that I don't frankly understand, maybe that would make sense, but not in accordance with a common understanding of the English language. So I just want to lodge a protest and say that I don't think it's appropriate for the chairman, after every time somebody on this side of the aisle asks questions of the judge, you come back and you denigrate and you attack and you criticize the line of questioning. I think the judge is doing a pretty good job of defending her own position and answering questions. So thank you for giving me a chance to express my objection to the way that you've been editorializing after each time this side of the aisle asks questions.
Thanks, Senator
Mr. Chairman.
Excuse me.
Mr. Chairman.
Excuse me. Thanks, Senator Cornyn. It's known as chairman's time.
Could I make my statement first?
You want to make your statement?
Yeah.
Well, may I respond to what Senator Cornyn said?
Well, if you want to speak before
May-
you're a
may I?
ranking member,
Thank you.
Harley, you're right.
Mr. Chairman, I agree with Senator Cornyn. You and I have talked about this before. I have great respect for you. You know that. But I've had the same issue in normal hearings, non-Supreme Court hearings, where you make editorial comments after I question. I appreciate your input, but they're not offered in an even-handed way. And I just don't think it's productive. I mean, you just referred by name to Senator Hawley. I think he should have a chance to respond. You know, this is America. We have the right to express ourselves. You know, you're not free if you can't say what you think. And I want to join my colleague, Senator Cornyn. I just don't think it's appropriate, Mr. Chairman.
It's called chairman's time. It is a tradition in this committee exercised by Senator Lindsey Graham as chairman and Senator Grassley in previous Supreme Court.
But they
No,
didn't
I'm
do it
gonna-
the way you do it,
I'm
Mr.
going to
Chairman.
allow you to be heard, but I want to be heard
Of course.
without interruption.
Of course.
And so in the minority, we waited through chairman's time when we had Republican chairs. There will not be a separate set of rules for Democrats in control of this committee. That was used as a response time and again by both of those senators, and it was accepted. If what I said was somehow problematic or painful yesterday, I'm sorry, but the Democrats are going to use the same mechanisms that the Republicans have used in this committee.
And I appreciate that, Mr. Chairman. But I think if you're going to personalize it as to senators by name, you ought to give them a chance to respond.
Well, they will have a chance. As a matter
Mr.
of
Chairman?
fact, each and every senator has 20 minutes today to respond if they wish.
Mr. Chairman,
Who's seeking? Senator House?
could we hear from Ranking Member Grassley, and then I'd like the opportunity to ask questions on behalf of the state of Georgia. I think the American public is now tuning into these proceedings expecting a substantive discussion of matters of grave importance to the country with a nominee for the Supreme Court before us. I don't think we've set an appropriate tone by bickering over time and process at the outset of our proceedings. Every senator deserves to be heard. I would like to humbly request that Ranking Member Grassley make a statement, that I and Senator Tillis have our opportunity to question the nominee, and that then we can litigate balls and strikes from yesterday.
Senator Ossoff, my statement doesn't quite fit in with what you asked, but I feel like I have to say it anyway because of the conflict that happened late last night. But before I do, I want to, somewhat tongue-in-cheek, but with some seriousness as well, when the chairman quoted Biden as saying that Justice Jackson, or Judge Jackson, handled herself with grace and dignity. I want to compliment the Democrats on this committee for using grace and dignity, unlike it was during the Kavanaugh hearings. Thank you all very much for making this. I've heard a lot of compliments about how this is a way a hearing ought to be held. So I want to address that issue that was raised yesterday about records. Senator Cruz raised a very legitimate question about data related to U.S. probation officer recommendations. The White House and members of this committee use that information to attempt to discredit information raised by Senator Hawley and others about the nominee's sentencing record as a district judge. No one on our side of the aisle had access to this information. In fact, before this past week, I'm not sure anyone but the probation office and the court had access to this information. My understanding is that the probation office recommendations aren't part of any public record. The specific sentencing recommendations aren't always shared with prosecutors or defendants. Somehow it appears that the White House obtained this information. It was leaked in pieces to media outlets in order to cast doubt on legitimate members' questions, and then it was provided to only Democratic members of this committee without any of the underlying documentation. I'd like to add my name to the letters that are requesting at least, well, this is Senator Lee's letter, request for at least the probation office recommendations so that we can be sure of the data handed out by Democratic staff last night. I'd also like to add my name and have added my name to Senator Cruz's follow-up request for access to any other data that might be shared with our colleagues on the other side. One last thing to suggest that all that we have to do is ask for information doesn't pass muster. You can't ask for information you don't know if it exists. I've asked for non-public records related to the judge's tenure on the Sentencing Commission. Those have not been produced, just like 48,000 pages of records withheld by the White House. How is the United States Senate supposed to review a record that we don't have? This process might be timely, but it's neither thorough nor fair to the American public, and I hope we can rectify that. I yield.
Thank you, Senator Grassley. Senator Ossoff.
Thank you, Mr. Chairman, Ranking Member Grassley. And Judge, good morning.
Good morning, Senator.
Welcome back.
Thank you.
We had a late night doing our job as senators and you as a nominee, and we're off to a morning start. I was considering asking you if you were a coffee or a tea drinker, but I thought that might be too personal and immaterial to the question of your nomination. I want to begin inspired by the presence of my brother, Senator Reverend Warnock, who's joined us this morning, in a spirit of national unity, offering thanks for these proceedings, for our Constitution, for this opportunity to air in public before the American people a vital grappling with ideas core to our republic, questions of the role of branches of government, questions of the proper role of judges in our society, questions that keep the peace and ensure that this remains a nation of laws. As I noted in my opening statement a couple of days ago, democracy is the exception and not the norm in history or around the world, and this public exercise is a vital one. And so I'm thankful for it. I'm thankful that the American people have the opportunity to observe it. And I'm thankful for your presence, Judge, for your service to the country throughout your life as a district judge, as an appellate judge, as a member of the U.S. Sentencing Commission, as a nominee for the court. So thank you for being here. Thank you for subjecting yourself and your family to an intrusive, at times cruel and unfair, but on the whole necessary and proper process of scrutiny as you are considered for this appointment. The American people who are now tuning in for the second day of these proceedings are hearing about your approach to the law, to your role as a judge and as a potential Supreme Court justice, and they're also getting to know you personally. And we've had the opportunity to hear a bit about your family, your background. I think it's also appropriate that the American public hear a bit more about your brother's story as I understand it, served the Baltimore Police Department, served in the U.S. Army. Before we turn to matters of law, will you please help introduce yourself and your family to the American public as you seek this lifetime appointment? Tell us a bit about him and his story.
Thank you, Senator. My brother followed in a long tradition in my family of public service. It was a core family value. My parents were both public servants, and two of my mother's brothers were career law enforcement. And my brother and I are almost a decade apart in age, and he, I think, looked up to my uncles, who were often around in their uniforms, keeping their weapons away from the kids by putting them up on high shelves, and we looked up to them, and we understood through their service what it was for their criminal behavior. I also, as a lawyer and a citizen, believe very strongly in our Constitution and the rights that make us free. And what that means to me is an understanding that although we need accountability, although there is crime, we also have a society that ensures that people who have been accused of criminal behavior are treated fairly. That is what our Constitution requires. That is what makes our system so exceptional. My brother understood that as part of his work, and he also served in the military. He also decided, as many people did, to defend our country after 9/11, that he would go into the Army. And I remember when he made that decision, he had a college degree. He could have been an officer right away. He could have been a type of military officer that didn't have to actually be on the battlefield. And I remember saying, are you going to do something with, radio signals? Are you going to be behind the scenes? And he said, no, I'm going to be infantry, boots on the ground. He said, I believe strongly in the protection of our country, and if I'm going to be leading, I'm going to be out front. That's the kind of person my brother is. It's the kind of service that our family provides. And for me, what that meant was an understanding that to defend our country and its values, we also needed to make sure that when we responded as a country to the terrible attacks on 9/11, we were upholding our constitutional values, that we weren't allowing the terrorists to win by changing who we are. And so I joined with many lawyers during that time who were helping the courts figure out the limits of executive authority, consistent with what the framers have told us is important, the limitations on government. I worked to protect our country. My brother worked on the front lines, and it was all because public service is important to us.
Thank you, Judge Jackson. And let's talk a bit about limitations on power. Our Constitution is a document that renounces monarchism and instead establishes a republic. You, in opinion that has been widely cited, made the observation that presidents are not kings. What does that mean, and what are some of the most important bulwarks in our constitutional system against the abuse of executive power, against tyranny?
Thank you, Senator. Our constitutional scheme, the design of our government, is erected to prevent tyranny. The framers decided, after experiencing monarchy, tyranny, and the like, that they were going to create a government that would split the powers of a monarch in several different ways. One was federalism. It was vertical. They would split the powers between the federal government and states. Another was to prevent the federal government from itself becoming too powerful, from having all of the authorities, from having legislative, executive, and judicial authority concentrated in one place. So the Constitution, in its design, puts the legislative authority in Article 1 and gives it to the Congress, the power to make laws. It puts the executive authority in Article 2 and gives it to the president, the power to execute the laws. And it puts the judicial authority, the power to interpret the laws, in Article 3 and gives it to the court.